Hello, everybody. It's Jim Diamond back, and I'm presenting today again with Brenna Hanley, who's here. Brenna, say hello.
Good morning. Hello. Good afternoon.
Yeah, Brenna and I are presenting again, and Brenna, of course, is one of my all-time favorite National Tribal Trial College students, and so I'm so pleased to be presenting with her again today. All right, our topic this session is cross-examination and closing argument. And we've been talking about cross-examination all week long, and you've had a couple of sessions where you've been lectured about cross-examination. So to some extent, this will be a review, but can't go over this enough. We'll be talking about cross-examination again. We'll be talking about use of the tactic of impeachment for cross-examination as a part of cross-examination. And then we'll be talking about closing arguments. So as we get to the near the end of our course, you can see we're getting to the end of a trial as well, and closing arguments. Talking now about impeachment of witnesses, and the current events of this year where a president was impeached should not confuse you. It's again, it's the same word, and it's used in a completely different way, but it is in fact the same word. It's used, it shows you why it was used in a political proceeding, because the impeachment of a president, like a witness, is something that's done to cast their behavior in a negative light. When we talk about it in the context of a witness or a hearing, what you're trying to do is to, in other words, say to the judge, you shouldn't listen to this witness, or you shouldn't believe this witness, or you shouldn't take the testimony of this witness and give it a lot of weight. And so impeachment of a witness is when you are trying to somehow cast a negative light about that witness's testimony, not about the witness in general, okay, not about the witness's character, but about the testimony. Some reason why you shouldn't listen, the judge shouldn't listen to the witness, shouldn't believe the witness, or should not do in the hearing what that witness is asking for. Am I got that right so far, Brenna?
Yes, sir. Sounds good.
Okay. So when you go to impeach a witness, so you're going to use certain arguments to try to cast that witness's testimony in a negative light. But you can't just make things up. Okay? You can't make things up. You can only use things that you have a serious belief is true, a good faith belief is true. Perhaps it's something that's, and it should be something that's in the record, it's in the reports. It could be something that your client told you, but you better have, as an advocate, a pretty firm belief that it's true. Now, as I'm going to give a demonstration in a little while of what it would be like, you'll see what I mean. But you're going to use points to try to show this witness's testimony should not be believed, that are going to help you, okay? And are going to help you in getting your goal you have and obtaining success in this hearing, in prevailing in your theme that we talked about a couple of days ago, Brenna and I, whether that is proving domestic violence, whether that is proving a case for child custody, for child support, for a protective order, or or whatever it is. Okay, so impeachment again, generally trying to show that a witness should not be believed or their testimony should not be given a good amount of weight. All right. So here are some of the common ways that we can do that. Well, one way is contradictory facts. So Marvin testifies on the stand that he wasn't even on the Green Mountain Reservation on the date in question, that he was somewhere else. He was fishing in Border City. He was hunting in Border City. Well, you would cross-examine him and impeach that testimony by bringing out facts that tend to show that Marvin's not telling the truth. And by putting on witnesses that show that he's not telling the truth, or in fact, cross-examining him about that. You say that you were hunting on April 1st in Border City, but you were here when Officer Olson testified that he saw you on Green Mountain. You were here when Shirley testified that you were on Green Mountain and you assaulted her. Isn't that true, Mr. Walker? So you impeach the witness during cross-examination with contradictory facts. Now, the second one is really hard to do. But you can cross-examine a witness and try to impeach them, try to show they shouldn't be believed, try to cast them in a negative light if they have criminal convictions, okay? And the rule of thumb here, and it's followed in most places and certainly in the federal rules, and it could be different in your tribal court, but the general rule of thumb is that you can only do that with convictions that are recent enough, about the last 10 years or so, and they're not juvenile convictions or youth convictions. They're not cases that were somehow dismissed in some sort of diversionary program, like Navajo peacemaking. They are adult convictions, and this is tricky to do because and the way you would do it, is to say to Marvin's testifying, you're cross-examining him or anyone else, and usually you want to cross-examine them with some criminal conviction that tends to show they're not truthful. So there are crimes that tend to reflect badly on a person's truthfulness, and there are others that don't. Like a DUI, operating under the influence, OUI, DWI, whatever it's called in your jurisdiction, that doesn't really reflect on a person's truthfulness. And I don't know that I would do it unless intoxication is an issue in the case. But theft, for example, theft is a crime that reflects upon honesty and dishonesty, and I would try to get in any theft conviction as impeachment, even a shoplifting, because it tends to show that a person is not honest because they stole. It's kind of complicated, and what I would do is if I know that the witness who is testifying has a reputation for having a criminal record, I would ask Brenna, I would ask the prosecutor in a criminal case to turn over the criminal record. If I'm a prosecutor, I'm going to ask the police department, my tribal police department, to run a record check on the witnesses. And they don't always do that automatically, so you've got to ask for it. Generally speaking, the advocate's not going to have access to these the NCIC records. So you have to actually, and in tribal court, it may not be so easy to get it. State court, they're going to have it automatically. Federal court, they're going to have it automatically. But you've got to ask for it. Or if it's common knowledge that your witness, has a couple of burglary convictions, and you have a good faith reason to believe that, then go and ask the question. Brenna, can you help me out on this at all as a tribal prosecutor? Do you guys use adult convictions and record checks in cross-examining witnesses?
Yes, we do. We do, but it all has to be disclosed prior to. But I wanted to mention that some ways that I've done it were there's things called dispositions, witness interviews that happen prior to the hearings. So that's one way I like to do it. And then I get the transcript and make sure I always have the transcript of that interview with me. So that way, if once I hear something that doesn't match up to my transcript, that's when I'll jump up, or I'll start thinking about how I want to impeach their statement that they just made. And then the bias and the interest, one way that I've done it before is in a battery case. The defendant's mom was testifying, and just everything we know was not truthful. And so at the end, when we got to cross, one of my last questions to her was, so he's your son, right? Yes. You love him, right? Yes. You would say anything to benefit him, yes. So kind of just going in that direction of the interest and the bias that she's favoring her son is one of the ways that, I like to ask the questions when it comes to like relatives and family friends. But also the impeachment, you always want to make sure that you know your facts. You have to know your facts. You have to know your storyline. So that way, when you do hear something that's inconsistent with, what that can be like a little trigger to, oh, maybe this is an impeachment opportunity.
That's great, Brenna. So I've never heard of that disposition transcript before, but I learned something every day. Absolutely. So whether it's something like Brenna has just mentioned about a disposition transcript, or the actual, an actual printout of a criminal conviction, if you're going to ask the question to the witness, you want to try to have something like that, like Brenna just said, because the witness is going to try to deny it. Remember, they're going to try to weasel out of all these things. So, but Brenna just described something very important, and it's more significant in tribal court than in federal or state court. And that's, you're going to have relatives testify. That's just, the judge might even be a relative, right? Brenna might be someone's relative, especially, not as common in a large tribal nation like the Navajo Nation or the Cherokee courts. But in a small tribe like your California rancherias, there's a pretty good chance that people involved are going to be related in one way or another. And so when Auntie comes to testify on behalf of a witness, or Grandma comes to testify on behalf of a witness, now with Grandma, be careful. But they've got an interest. They want to see, Sonny Boy or their grandson or their cousin. They want to see them win. They want to see them prevail. They don't want to see them thrown out of their house. They don't want them to have to pay child support. They don't want them to lose child custody. So they have an interest in the proceeding. They have a bias. And it may seem really obvious to you that, that Marvin's mother has an interest. Yeah, it is obvious. And, don't beat a dead horse, but just say, like Brenna, just exactly the way Brenna just did it. And Mrs. Walker, isn't it true you'd like to see your son prevail in this hearing? Now, she might say, no, I don't care. She might say, yeah, but and when Brenna asks the question, you do anything for him, and she says, but I would never lie for him, just leave that answer out there. Because in cross-examination, as we talked about in previous lectures, as other members of the faculty have talked about, that's the question that's important. So let the question hang there, and don't worry so much about his answer, right? No. The grandma says, no, I would never lie for anyone. You don't worry so much about the answer. Because it's the question that's important. Because in cross-examination, we want, as much as possible, the advocate or the lawyer to be doing the talking. We want the less and less words to come from the witness. You want to, because this cross-examination is about control, because you want to get your arguments out there. You want to get your point out there, and you're allowed to do it. In fact, we encourage you to do it on cross-examination. Ask leading questions, ask tough questions, a rigorous examination. That's what cross-examination is. And you're allowed to do it with contradictory facts. You're allowed to impeach with adult convictions. And you're allowed to do it, as Brenna said, with showing that the witness has some bias or some interest. And again, don't be afraid of the answer. And as best, don't worry if he says, if the witness says, I would never lie for him, just ask it and keep asking your questions. All right. The next way that we do it is to show that what the witness just said on direct examination is different than what they said in some other statement. Okay? They've given some prior inconsistent statement. What they said at some other time, whether in this case or some other case or somewhere else, is different than what they're saying now. And so the way you do that, we talked about a couple of days ago. I talked about it, and Jim White talked about it, and Cousin Amy talked about it. Is being organized. So you have to go, and we talked about it a couple of days ago. Your trial notebook, your trial folder, having these things handy. That's why when, what I do is I have a little folder for every witness I know is going to testify. And in that folder, I've got everything about that witness, including the points I want to make on cross-examination in advance, or direct examination if that's what I'm doing. But I've got, if they've made a prior written statement, okay, or an oral statement, right, that I know about, I'm going to put it in my folder for that witness. If you're using a trial notebook, I'll put it in the tab section for that witness. And I'll have more than one copy, right? Because I've got my copy and I've got an extra copy that I can run up to the stand as I cross-examine Marvin Walker or whatever witness it is. And I can say, okay, Mr. Walker, you just testified that on April 1st, you were hunting at the time of the McDonald's incident. Isn't it true, however, that you previously gave a statement, okay, that Shirley attacked you at McDonald's? No, I didn't say that. Oh, okay. You go up front and you say, and you ask for Marvin's prior statement, which you've got, right? You've got his prior statement. It's in your materials. And you ask the judge to mark it for identification only. All right. And so now you take Marvin's statement and you see, Judge, can we mark this as plaintiff's 6 for identification only? Give it to the judge or the clerk, ask them to mark this statement for identification. And now I've got it and I can talk about it. The reason why you want to mark it for identification is because they're keeping a record of this, right, in case there's an appeal. All right. It's also because I can't wave around this piece of paper without referring to it so one way or another. So now I've got this Marvin's statement he made to the Green Mountain Police, and it's been marked as Plaintiff's Exhibit 8 for identification. So now I ask, Your Honor, can I approach the witness? The judge is going to say yes. Now I say, all right, Mr. Walker, I'm now going to show you Plaintiff's Exhibit 8 for identification, which is the statement you gave to Officer Olson on April 3rd of this year. Would you just take a look at this for a moment? And I don't want you to say anything. I just want you to look at it. And I would like you to read this statement to yourself. Okay? And now you back up. And Mr. Walker, when you're done reading the statement, please look, I'll ask for your attention, but just read it to yourself, Mr. Walker, okay? Now you step back, let Marvin look at it. Okay, he looks up. Okay, now you impeach him on his prior inconsistent statement. Mr. Walker, you just read the statement you gave to the Green Mountain Police, Officer Olson, on April 3rd. Didn't you tell Officer Olson that you were at McDonald's and that Shirley attacked you? Okay, that's how you do it. Now he's testified to something that was different than what he said in the statement, and that's how you impeach him with a prior inconsistent statement. Anything to add to that, Brenna, at all?
Yeah, I just had an example of a criminal charge that I was going forward with, and at the same time, I learned that a protection order hearing had already happened. So I went and got the recording, and sure enough, his statements weren't matching up to when he got recording for this purpose, just in case I needed to use it for the criminal hearing. Because I already knew his statements were not lining up. So that was just one example. And when you do these impeachments, sometimes you really make the witness uncomfortable. And sometimes they're not gonna give you a straight answer. They're not gonna say, yes, I'm a liar, or I'm being dishonest. They'll try to, not answer you. The way that I like to tell the witnesses, one of the last questions I just like to remind them is, hey, you remember taking the oath before you say, yes, I took an oath and I swore to tell the truth. You can do. It's just so different with every situation. So definitely there are ways, and practice makes it all better.
Yes. Thank you, Brenna. Brenna is absolutely right. First of all, it's hard to do. Cross-examination, using prior inconsistent statements is hard to do. But they are going to try to wiggle out of it. They're going to say, they forced me to make that statement, or, I'm telling the truth today. One way or another. If he says, today I'm telling the truth and I was hunting on April 4th, so now you've got, well, Mr. Walker, are you saying that you made a false statement to the police, the Green Mountain Police, your tribal police? You gave them a false statement? Well, I guess so. So now what's he going to do now? So then I would say, well, Mr. Walker, you don't want us to believe a statement that you swore was true on April 4th. You want us to believe you today, but we really can't believe anything you say, can we, Mr. Walker? Now, he's going to hate me for doing that. It's not fun to do, although I kind of like it. And it's not easy to do. But Brenna is absolutely right. He's going to try to wiggle, and if it, and that's human behavior. Unless you've got grandma on the stand, and she's honest and has integrity, and she's just going to say, I made a mistake. But most likely, be prepared. for him trying to wiggle. Okay.
Yeah.
You can also, so again, you can try to impeach the witness, and it doesn't have to be Marvin. It could be any witness. By showing contradictory facts, inconsistent facts that show that the witness who just testified on direct exam, is not credible. So look, an example, perfect example of a witness that we have in your packet who might testify and might testify falsely is cousin Stan. Okay, if Marvin calls cousin Stan to testify, be prepared that cousin Stan is going to try to help Marvin out and is going to offer up contradictory or inconsistent facts or facts that just didn't happen. He's going to try to do that when Marvin calls him to the stand on direct examination and on cross-examination. You're going to try to impeach him with those inconsistent, contradictory facts. Again, you have to have a good faith belief in what you're using, that the facts that Stan's testifying to is not truthful. And it helps if you've got some other witnesses to back you up, to corroborate your version of it. That's something that you do on cross-examination. Okay, so here just are a couple of examples from our fact pattern. Marvin says Shirley makes things up. She's accident prone. But you might say, well, Mr. Walker, you've seen, you say she's accident prone, she ripped her own shirt. Well, you were here when she testified that you ripped her shirt. You were here when Officer Olson testified that he saw the shirt ripped right after the incident. And in fact, you've seen Exhibit 8-2, the ripped shirt itself. Isn't that right? And then he's going to try to wiggle out of it by saying, yeah, but I didn't rip it. Okay. Let him. Move on to the next question. He'll say that, Shirley ran outside, to the neighbor's house. But Marvin, you were the one who were arrested. Isn't that right? So you're going to try to impeach him, with these contradictory facts during cross-examination. Anything to add, Brenna, before I move along?
No.
Okay.
Sounds good.
Okay. All right. I'm going to try to do a little. I'm going to show you how I would do it, and let me just stop sharing the screens for just a second. Let's see. So, okay. Can you guys? I assume everyone can see me now. I'm going to try to do it now, and this is a little awkward. If we were live, I would ask someone like Daniel to be Marvin, and I would cross-examine him like I like to do, and impeach his testimony. Okay, so what I'm going to do now, and so what I'll do is I'll just change my voice when I'm me and when I'm Marvin, and you'll know when I'm me, and you'll know when I'm Marvin. But anyway, so let's say, hypothetically speaking, Marvin just testified that he never ever hit Shirley Walker. Never once has he ever hit Shirley Walker. Okay? And now he did that on direct examination, and now it's my turn to cross-examine him, and I'm going to try to impeach him on the statement that he never ever hit Shirley Walker. Okay, all right. Okay, Mr. Walker, you testified that you never hit Shirley Walker. Isn't that right? Yeah, that's right. Mr. Walker, you want to win this hearing. Isn't that right? Well, I don't know. And you want the judge to rule in your favor. Isn't that right? I don't know. And Mr. Walker, You don't want the judge to take away your paychecks, isn't that right? I don't give a damn what he does. Now, you don't want him to give your paychecks to Shirley, isn't that right? No, that's not right. You don't want him to tell you what you can and can't do. Isn't that right, Mr. Walker? Well, Your Honor, please, these are yes or no questions. Please direct Mr. Walker to answer them with a yes or a no. Thank you, Judge. Mr. Walker, you don't want this judge to tell you what you can do and what you can't do. Isn't that right, Mr. Walker? I guess. And you don't want this judge to take your truck away from you, do you? I don't know. You don't want him to take your 2 children away from you, do you? And in fact, you know, Mr. Walker, that if you admit here today on the stand that you beat Shirley, he's going to take your children away from you. Isn't that right? I don't know what he's going to do. And you heard Shirley testify that in April, you punched her. Isn't that right? I don't know. You were here, sitting here, Mr. Walker, when she testified a few minutes ago that you punched her in the face. Didn't you hear her say that? Yeah, she said it, but it's a lie. You heard her say it, Mr. Walker. Isn't that right? And you also heard Officer Alston, Blue River Officer Alston, testify that he got there and he saw Shirley bleeding from the mouth. Isn't that right? I don't know. And in fact, at that time, he came in and after seeing Shirley bleeding from the mouth and investigating the case, you were the one who was arrested. Isn't that right, Mr. Walker? Yes. Okay, Mr. Walker, you were here, okay, when you said you never, in fact, assaulted Shirley Walker. Didn't you sit here and watch the videotape of the McDonald's incident where you're seen hitting her over the head with a gun? That wasn't me. Oh, it wasn't you, Mr. Walker. And Mr. Walker, you're here and you've seen the exhibit, a photograph, I-6, that's taken of Shirley's injuries. Isn't that right? I don't know who did that. Mr. Walker, as you sit here, do you still want this judge to believe you never assaulted Shirley Walker? I don't know. That's how I would recommend doing it. If I could get my screen again. Okay. Any comments, Brenna?
No, that was good, Jim. That was good.
Okay. Let me go back to my. Thank you, Brenna. Okay. So that's how I recommend doing it. I apologize for my Marvin imitation, but you get the point. Ask the questions. Ask them in a leading way. Use the facts to contradict him. Use the evidence to contradict and to impeach him. And don't worry so much about the answers. And when he tries to wiggle out of it, sometimes ask the judge for a little bit of help, directing him to answer the question with a yes or no. But that's how it's done. Okay. Cross-examination bears an important relationship to closing argument. Remember that it's the testimony of the witnesses I just, everything Marvin says is evidence, and everything the lawyer says is argument. It's not evidence. It's something that can be considered by the judge, but it doesn't add to the weight of the evidence. We're going to be talking in a few minutes about closing arguments, and closing arguments are, in fact, words of the lawyer. They're not evidence, but they're important. Now, the way I like to use cross-examination in a closing argument is I anticipate what's going to happen on cross-examination, because I kind of know my case. I'm well prepared. I'm like Brenna Hanley. I'm ready. I'm prepared, and I anticipate those arguments and the testimony of the witnesses. So I build that into my outline of my closing argument that I've already prepared. Okay. Now, in the closing argument, I'm going to comment on the believability of the witnesses that testified on the other side. I'm not going to, I don't like to come out and call witnesses liars. Pretty much do everything but that. I'm going to say something like, you were here. In my closing argument, I'm going to say, you were here, Your Honor, when Mr. Walker testified. And you heard him testify that he was hunting at the time of the McDonald's incident, when in fact the court watched the video and saw him assault Shirley Walker on a videotape. So Mr. Walker is not a witness who the court should believe. That's the way I would do it, rather than call him a liar. I don't think you want to do that in court. I don't think anyone likes it when you do. But you can comment on their credibility in your closing argument. You would, if a witness testifies on direct and cross in a way that's not all that important to the hearing, I'd let it go. I wouldn't talk about it in a closing argument. But I would use anything that came up in cross-examination in helping me to frame my closing argument. Anything to add, Brenna, before I go to the next slide?
Yeah, just quickly before I forget, one of the good practices that I started when I first started was, as soon as you're done with cross examination, jot down some notes, have some paper ready.
That's a great point.
Words that stick out to you, that way for the purpose of your closing argument. Yeah, there's like keywords that they may have said themselves. I'll jot those down. And it's a really uncomfortable situation. A lot of times when they do start trying to wiggle out of during the cross, you'll see them cross their hands, you'll see them getting upset. So I usually read that as, okay, that's a soft spot for them, so that, the judge sees them crossing their hands. Everybody sees their demeanor during that time. So I look out for some of those things, because that's when I know that, okay, we hit a soft spot. So I'm going to highlight that in the closing. So just to keep it on your mind, just jot a note down, and then during closing, you can look down. And then if you want to throw a specific word that they may have used, then I would. If they said liar, or called somebody else a liar, or use some word that just sticks out, I would just jot that down. And if it worked, maybe quote them during the closing.
That's great. And so, as Brenna says, the way that I do that is, me with my folders, right? So I'll, whether you're using folders or you're doing it all on your computer, I don't do that. Or you have a trial notebook.
No, I don't.
Have a folder for closing argument, and take notes all throughout the hearing or the trial on things that you want to write yourself a note. Bring this up in closing, because sometimes you're given very little time before a closing argument. Sometimes no time, or you might, if it's been a couple of day hearing, which is rare. But if it's been a long trial, a couple of days, your closing argument could be, you could finish up on, Friday at 2 o'clock, and the judge can say, we'll have closing arguments on Monday. And so, you'll have all these notes that you've been preparing for your closing argument. So like Brenna says, jot some things down, whether it's just, a couple of words, quotes, things that came up during someone's testimony that you don't want to forget, and that you want to remember and use in your closing argument. I'm getting old, and so I tend to forget things, and if I don't write notes to myself, I'll forget them. Hey, I'm not that old. Anyway, okay. So closing arguments. Okay, right, Brenna? All right.
Yes, you're not old. You're
No, I'm
not
not
old.
old. Okay, not at all. Okay, closing argument. So this is when you sum it all up. Um, it's argument again. It's not evidence, but it's really important. This is the last chance you get to ask the judge to rule in your favor, or if you happen to be in front of a jury, this is when you get a chance to bring it all together. While if it's a trial and there's been several witnesses and it's gone on a couple of days, you didn't get a chance to tell the judge while it was happening how it all fits in. You put in exhibits, you put in reports, you put in photographs, you had your witnesses testify, you had your victim testify, you put in a medical report, but you didn't get a chance while that was happening to tell the judge how it all fits together. Now is when you do that. Now is when you tell the judge how it all fits together and why you introduced those things during your case, right? Why you introduced those during your case and how they fit together. It's also when you get a chance to tell the judge how these facts fit together with the law of your jurisdiction. If it's your tribal court, the law, your tribal codes. If it's a state or federal court, your ordinances or your statutes or your federal law, how it fits in with the law of the case. Where that could be case law, right? That could be traditional law, like Brenna talked about a couple of days ago. How the facts, right, fit together with the law of the case. Let's say we're talking here about the law of what the definition of assault is in your jurisdiction, or what the definition of strangulation is in your jurisdiction, or what the definition of child custody is in your jurisdiction, or what the definition of domestic violence is in your jurisdiction, in your court. And so you're going to, in your closing argument, you're trying to get the judge or the jury, if it happens to be a jury, to believe your version of the facts, because there's more than one version of the facts, right? Sometimes there's two versions of the facts. Sometimes there's three. Sometimes there's four. There's a lot of different versions of the facts out there. You know what I mean, right? Because the facts can be messy. They can be confusing. Even some of your witnesses might have disagreed with what happened, right? The way I like to point that out is, one witness comes in and says, there was this car accident, and, when they got to the intersection, the light was red, one witness says. And then the next witness comes in and says, when the cars got to the intersection, the light was yellow. And then a third witness comes in and says, yeah, when the cars approached the intersection, the light was green. And then a fourth witness comes in and says, what? The intersection of Main and Green Mountain Avenue? There's no light at that intersection, right? And so at the closing argument, you want to convince the judge, jury, if it happens to be a jury, if you're so lucky, you want to convince the judge that your version of the facts, the light was red, for example, should be believed. But I want you to accept what I'm saying, that the facts are going to be messy. It's your job to try to clear them up. It's your job. That's your job. And it is hard. But the facts are messy because life is messy. And it's not just cases in tribal court. Believe me. Life is messy. When it gets to court, there's so much stuff going on. Just look at this case. All these different arrests, all these different incidents, all these prior times of incidents of domestic violence, who's been arrested, what happened in Green Mountain, what happened at Blue River, what happened at Border City. It is confusing and it is messy, and it is going to be messy in your case. You have to master the facts and convince the judge in your hearing, and this is the time to do it, to accept your version of the facts. Okay? Your version of the facts, your legal conclusions as well. Brenna, am I making it up? Is it going to be messy or is it going to be clean?
It's gonna be so messy, clear as mud.
Yeah.
And then because of the impeachments, you're gonna try to impeach other people, and opposing counsel is gonna try to impeach your witness. So yeah, just keep an open mind and take notes and remember facts, good facts.
Right. Okay, so how are you going to prepare a closing argument? You want to, again, go over the facts and your version of the facts, and that you want to be established during a closing argument. And then you want to write an outline of it. Now, we strongly discourage you from writing it out. I think the best rule of thumb is to have an outline with bullet points of the points that you want to make in your closing argument. Now, I'm not going to lie, because I don't do that. I'm not going to lie and say I've never written out an opening argument or a closing argument. I have. But what I will do is, if I have as the time to do it, like the next point, practice it. Practice it, practice it, practice it. The best way to do it is with bullet points and an outline, and to practice it. And the more familiar you are with your closing argument, the less reading you'll do and the more eye contact you'll make. Also, if you're doing it with that method, you can make changes to things that happened, an hour ago in the hearing, right? Toward the end of the hearing, that you didn't have a chance to put in your outlines. But you want to try to be obvious that, that you were listening throughout the whole trial and you were preparing, and that and you want to include things that happened throughout the trial. Again, I think, an outline with bullet points. Sometimes when I do public speaking, my rule of thumb is to use nice large 5x7 note cards that you can buy for $1 or so, and use them, because then I'm not going to be I know I'm not going to be reading it. Okay. How to structure an effective closing argument. Try, like the rule of thumb for all public speaking, try to start out strong. Remember when Brenna and I spoke a couple of days ago about your theory and your themes? Start out with that, what your theme of the case is. Reintroduce your theme, reintroduce your theory, define the issues. Now, the issue in the case is, differs in every case. So the issue can be, this is an order. It depends on what kind of hearing you're in. So if you're in a protective order hearing, the issue is, whether domestic violence occurred, or an act of violence that endangers your victim, was domestic violence proven? That's the issue. If it's a child custody case, Did we prove to the court that our client is deserving of custody, whether it's full custody, limited custody? Define the issue. Okay. You could be making a sentencing argument. The issue is whether Mr. Walker should be incarcerated, fined, or sent for counseling. Sometimes, because it's so muddy, as Brenna said, you might want to state what clearly is not at issue. And that is important to do as well. If you're in a protective order hearing, okay, and what's not at issue is whether Shirley, should be convicted in criminal court of assault at McDonald's, you state that. We're here for a protective order. Whether Shirley assaulted, Marvin at McDonald's is not at issue. So it's important in a muddy courtroom to state what is at issue and what's not at issue. Definitely discuss the applicable law, whether that's the code, right? Your nation's tribal code, whether it's a state statute, a federal statute, right? Or as Brenna has talked about, traditional law, common law of your nation. That's a way to structure it. Okay, when you talk about the law of the case, you should again, talk about who has the burden of proof. And we talked about that a couple of days ago as well. We've been talking about that all week. Who has to prove what in this hearing? Again, it's usually the plaintiff, the person bringing the case, who has the burden of proof. In a criminal case, it's Brenna, the prosecutor. The nation has the burden of proof. The defendant, the person who or the respondent, the person who is responding to the complaint, does not have the burden of proof. The plaintiff does. And so that, again, that means that the plaintiff has to bring the evidence, has to introduce the evidence, has to bring the witnesses. Although the defendant doesn't have the burden of proof, right? It doesn't mean that if you're advocating on behalf of a defendant, or if you're representing the defendant, as I have done, it doesn't mean they shouldn't introduce evidence or that they won't introduce evidence. It just means that under the law, they don't have the responsibility of proving the case. The plaintiff does. And again, you'll want to talk about the standard of proof. How much evidence is required in that hearing for the plaintiff to win? And that differs in all different kinds of hearings. Just a quick review again. In a civil case, like a protective order case, it usually means that they have to bring enough evidence that they have brought in enough evidence that their case is sustained by a preponderance of the evidence. Usually means, more likely than not. If it's a criminal case, the burden of proof usually is in Western courts and tribal courts as well, typically because they have followed Western law, they follow the Anglo-American British system. In a criminal case, it usually means that they have to prove the case beyond a reasonable doubt. And I don't know, I can never really tell you what that means, although I've been practicing criminal law on both sides for an entire lifetime and 30 years. I really don't know what it means. I think it's what I would call a legal fiction. And I don't, but it's a lot of evidence. It's pretty darn convincing, right, Brenna?
Yeah, and I like to look at it like beyond a reasonable doubt is you can't just identify the incident that happened. You have to take it beyond the incident. You have to prove beyond what the initial incident facts. You have to take it beyond that to prove beyond the reasonable doubt that that did happen.
You have to have, thanks for trying. And Brenna, look, I think that, it's one of these things that I call a legal fiction. It's mumbo jumbo. And I'm being honest. I sat there as a prosecutor listening to the judge tell the juries, and I did my share of criminal jury trials on both sides of the courtroom. I listened to the judge tell the jury what it means, and I'm smiling there, shaking my head. I don't know what they mean. But the way I would explain it is in a criminal case, it's, you can't just have a hint of guilt. It's got to be established, convincingly. The three standards that exist are by preponderance of the evidence, by clear and convincing evidence, or proof beyond a reasonable doubt. You're going to tell in a closing argument, you're going to say to the judge what that standard is, and you're going to show the court how you met that burden of proof, how you met the burden of proof as the person bringing on the issue, the case. You're going to talk about what the ultimate legal issue is. You might go through important definitions. You might talk about case law that supports your position. If you've got a case on your nation or on some other tribal nation that helps you, try to find a way to copy that decision, print it out, have it handy. You can even hand it up. It's really effective to hand it up to the judge and show, Your Honor, in fact, in a neighboring district, in Kayenta, the district court ruled in a similar case that it is a way of our nation that child custody is favored in the mother due to our history of children going into the mother's clan. And so, for example, that's just an example that I'm making up. I think that there is a Navajo case that says that, but I'm making it up. But you can, have a, if your court in your district hasn't ruled yet on this issue that's in question, but they have in a neighboring district, you can cite that. If there is a conflict between, I don't know, Window Rock and Kayenta, don't be honest about that and say, Your Honor, I know that in the nation, some of the district courts have ruled differently, and our nation's Supreme Court has not yet ruled, but we're asking you to follow the ruling in Kayenta, just hypothetically speaking, for example, and have a copy of that court decision handy. Okay, in your closing argument, you want to argue, again, make those muddy facts less muddy, argue the facts and how they fit into the law. You want to, talk about the facts that support your theory of the case. You want to talk about the facts maybe that the opposition brought up that make no sense at all. Come on, Judge, you don't really believe that Shirley ran into Marvin's fist, do you? You might bring up facts that are not in evidence, but you think you're well within your right to do so. Although that bullet point in our slide, I would advise you to be really, really cautious, because if you bring something up in your closing argument that's not in evidence, and you've got Jim Diamond on the other side, I don't like to object during closing arguments. I don't like to do it. I don't like when it's done to me. Brenna doesn't like when it's done to her. Nobody likes it when it's done. If you do it, if you bring in facts that are not in evidence, I'm going to object. Like, I'm going to interrupt the flow of your closing argument. I'm going to object. So be careful. You do, however, if you've got bad facts, Shirley arrested, Shirley maybe changing her mind in the past about domestic violence complaints. You want to maybe explain them, minimize them, acknowledge them in your closing argument, but minimize them. Show why they're not either, they shouldn't be dispositive in this particular hearing. Anything to add, Brenna, before I keep moving along? I got it right so far? I can't hear Brenna.
No.
I assume she's saying I'm right again. Okay.
Doing good, Jim.
Okay, great. Okay, so then at the end of your closing, at the closing of your closing, this is really important. Okay? And I should have said this at the beginning of our presentation. In your closing argument, you must ask for your remedy. You have a remedy. You have something that is the required result that you're asking for. The reason that you came to this hearing. Okay? You've met your burden. Now ask for the remedy. And it's a remedy. So when we talk about remedies, a remedy might be, it's what you came to court to get. It might be child support. It might be spousal support. It might be a sentencing argument where you're an advocate and you're making an argument on behalf of a victim, but there's a sentence that you are asking for. That's the remedy you're asking for. It might be the protective order. It might be guilt or innocence in a criminal case. Okay, it's a remedy. It might be damages, money in a civil hearing, in a civil case. It's the remedy. It's a legal solution to a problem. The best way I can explain it. In a domestic violence case, in a protective order case, you have ask for the protective order. Don't forget. And sometimes I've forgotten to do it. Sometimes lawyers have forgotten to do it. Sometimes advocates have forgotten to do it. Write yourself a reminder. Ask for the remedy. Ask for the required result at the end of at the conclusion of your arguments. Pretty much how I would end my closing argument. You might want to start your closing and end your closing with a little bit of a rhetorical flourish or a strong point, but don't forget to ask for your remedy. Anything to add to that, Brenna?
That's when I like to ask to find the defendant guilty. Your Honor, please find this.
Well,
no,
right.
Nothing else.
Right. Brenna's, right. A prosecutor at the conclusion of a criminal case, they've got a script. And, they're going to, the way I used to put it when I was a prosecutor, it's been a few years. No, really, it hasn't been that long. But when I was a prosecutor, I would ask the jury or the judge, if it was a bench trial, to issue a verdict. And the only verdict that is consistent with the evidence, and that is guilty. That's how I would put that in a criminal case. Okay, I'm going to now give a sample closing argument. Okay? And I'm going to give a sample closing argument in a protective order case for Shirley Walker. And I apologize if I do a little bit of reading. I apologize for not standing up. I would usually stand up when I deliver a closing argument, unless I'm in a court where the judge tells me to sit down, Mr. Diamond, which they like to do sometimes. Okay. I'm going to do a sample closing argument. Your Honor, Shirley Walker is an abused spouse. She's been abused for over a decade, and she has today sounded the alarm. It's an emergency. She sounded the alarm because today, Your Honor, is the time for action. Today is the time for the court to take some action to put out that fire, to address the alarm. The fire, Your Honor, is the anger and rage of Marvin Walker that has put Shirley's life in grave danger. Today is the day to protect Shirley, to assist Shirley, to end that vicious cycle of abuse that continues and repeats and endangers Shirley and endangers her children. The children, Your Honor, that are the future of our nation. This court has been given the power and the responsibility by our counsel to protect our people, to honor and to protect our traditions. The task of enforcing standards of behavior by our people. Yet, Your Honor, too many people on the nation, regrettably, have looked the other way, have looked away and have let this pattern continue. And so it has continued, but not today. Today is the day, Your Honor, we're asking the court to take action, to heed the alarm. And we ask today for this court to restore peace and harmony to this family and to build what I would call a canopy of protection, a wall of protection around my client and around this family. Your Honor, Section 4-25 of the Green Mountain Code defines domestic violence. And it defines domestic violence in the following way. I know the court is aware of it, and I know the court knows our code. I repeat it just for the sake of it being clear. Domestic violence on our nation means a crime committed by a current or a former spouse, by physically harming or attempting to place in harm or reasonable fear of harm a person. And, Your Honor, domestic violence has in fact been proven. We proved it here today. And we proved it by a preponderance of the evidence. We proved it with clear and convincing evidence. And so, Your Honor, we're here today to ask the court to issue an order of protection, to issue an order of no contact. And in fact, the court today heard evidence of violence that was perpetrated by Marvin Walker against Shirley Walker. She testified in April that he punched her in the face. Officer Elson testified here that he saw the evidence of that assault. He witnessed it himself, corroborated those injuries. Shirley testified that in May he punched her and strangled her. And again, Officer Olson came in and testified here before Your Honor that he corroborated that evidence of the assault and strangulation. And the court heard Officer Olson corroborate that testimony. The court has seen the photographs that corroborate the injuries. The photographs that are here marked as Plaintiff's Exhibit 1 that demonstrate, document those injuries. The court has seen the medical reports that are in evidence, Exhibit P2, that's before the court, that document, corroborate, and demonstrate those injuries to Shirley Walker. The court has seen the ripped shirt, which is in evidence, Exhibit P3, which is before Your Honor. The court heard the riveting testimony of what occurred on June 14th at McDonald's. And the court watched the videotape, which is in evidence, the Plaintiff's Exhibit P8, where the court saw Mr. Walker attack Shirley Walker and in fact strike her over the head with a gun. The court heard the testimony of how Marvin uses money to control Shirley Walker with clear and convincing evidence of economic abuse. The court heard the evidence that Marvin Walker earns $62,000 a year, and the court has seen the exhibits, his pay stubs, Exhibit P9, that's before the court. The court has seen his bank statements that document his assets and his income. That's before the court in Exhibit P10. Your Honor, finally, again, too many people on our nation have looked the other way and said it's not their problem. This court cannot look away. This court is given the task of protecting Shirley Walker, protecting our people, and protecting her right to lead a safe and happy, fulfilled life. That's what we're asking the court to do today. And with a preponderance of the evidence, with credible, reliable, convincing evidence, we met our burden. So today, Your Honor, I ask you for the following remedy. I ask you to issue an order today that Marvin Walker not assault or strike Shirley Walker. That the order specifically say that Marvin Walker not stalk or harass Shirley Walker. That the order say that Marvin Walker not threaten Shirley Walker. That Marvin Walker have no contact with Shirley Walker, direct or indirect contact. That Marvin Walker not enter the premises at Rural Road 222 Green Mountain. That Marvin Walker not possess any firearms. And if in fact he possesses firearms, that he turn them over within 24 hours to the Green Mountain Police Department. Your Honor, we're asking today the court to issue an order for Marvin Walker to pay $500 a month in child support, and for Marvin Walker to pay $500 a month in spousal support. Your Honor, I thank you for your attention, and we ask the court today to restore Shirley and her children to a place of peace, serenity, and safety. Thank you, Your Honor. That's my sample closing argument. Anything to add, Brenna?
That was a good closing, Jim. Just to close up our whole presentation, I just want to recommend, be calm, be confident, be comfortable, and the closing is like the icing on your story. You have a beginning, middle, end. Be confident and comfortable, but not too comfortable that you hold that piece of paper to read your closing, because I made that mistake. I held and read off a paper on a closing.
So have I. I admitted it before. Now we both admit it.
I was nervous. I wanted to, that was my security blanket, holding that paper and reading it, But the more practice you do, the better it'll be. But always be comfortable and confident during these stages of a hearing.
Now, Brenna and I have both confessed to using our notes as a security blanket. Look, If I do various things to make myself feel comfortable. I admit I have never, in 30 years of being a trial lawyer, I have never done a hearing where I wasn't nervous. If there comes a day when
I
I'm doing,
agree. Me too.
yeah, if there, and I've done thousands of hearings. If there comes and I'm still nervous when I'm walking to a courtroom. I'm more nervous when I'm in a courtroom I've never been in before. I'm less nervous if I've been in a courtroom that I've been in a lot of times. But there's many times I'm in a new courtroom, and I'm more nervous if I'm going into Marvin's home territory, like Green Mountain, and his relatives are all, got the courtroom all loaded up, and his uncle is the judge, his cousin's the bailiff, and he's chatting away with the court, security staff about, the times they've played golf together, or they've hunted together, or fished together, or, how's your cousin Joe? I'm even more nervous. If there comes a day when I am not nervous doing a hearing, it's time for me to stop being a lawyer. I am still nervous. And so I've got all these things that I do as crutches, Brenna. I've got certain books that I put on my desk every trial. I've got a book called by Professor Tom Maué, who was a colleague of mine at the University of Arizona. And he has a book on trial advocacy where he's got sample questions for how to get certain items into evidence. And even though I haven't looked at it in a trial in 15 years, because I once had a trial where I had in front of a jury in a felony trial where someone was going to get put in prison for a very, very, very long time. And I once had a judge kept saying, denied, 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 denied. Every time I tried to introduce an exhibit, until I actually looked it up in a book, in Professor Maué's book, and it once got me out of trouble. I now have never done a trial without Professor Maué's trial advocacy book on the desk. It's a crutch. I confess to it. I also am a creature of habit. I've got my notes. I am a creature of habit. I've done things, the way they were successful to me when, starting out when I was a new lawyer, even when I was a law student. I've got things and I'm going to stick with it because it's made me successful. And if you've got things that make you successful, whether it's your favorite pen, whatever it happens to be, use it. Like Brenna said, you're going to be nervous. Like Brenna said, don't worry about being nervous. If you're prepared, if you're confident, you're going to prevail. And if you don't prevail today, you're going to prevail in the long run because you're doing really, really important work. Okay? You're doing you're doing a task that no one else can do. You're trained, you are prepared, and if you're trained, and if you're well prepared, and if you're well organized, and you've got truth on your side, like you do in Shirley's case, there's nothing that can stop you. You'll be successful. And I have great faith that you'll be successful if you follow all of this training and all of your life experience, and you move forward with great confidence and follow the trailblazers who have come before you, people like Brenna and Hanley and me and Judge Bullock and Daniel and David and all of your faculty and your fellow students. You'll be successful. On that note, we'll see you in a few minutes and see you in the small groups, and I'm sure you're going to do a great job. If you have any questions about this presentation, any questions for Brenna, any questions for me, bring it up when we get together in small groups. Okay? On that note, we're done.